Hey everybody, it's me and Mo here, ready to learn about the judicial branch. Hey Mo. All right, she'll gradually fade away, but let's get going. So today's learning objectives, as Mo paces back and forth and hopefully listens and moves away soon, is understand the structure of our general federal court system, identify the difference and interpret the differences between state and federal courts, as well as criminal and civil courts. Also explain how and why and who we appoint as judges within the state federal court systems, in addition to our Supreme Court. We're going to look at the ideological makeup of our current Supreme Court and a very brief discussion about some of the courts in past, but it's important to acknowledge what our textbook identifies as our contemporary Supreme Court's ideological makeup, recognize what a landmark decision is, and explain the impact of a handful of most notable landmark decisions in U.S. history. We're going to look at, I believe, 4 specific ones, maybe a couple more than that, as I expand this every semester here and there. And then we're going to look at, as we do with every branch of the 3 branches of government, the distinction between the checks between the 3 branches of government. So let's get going. All right. As we've done so far, we're going to start by acknowledging what the Constitution says about this body. We remember that the executive branch, Article 2 of the Constitution, was relatively short. A lot of room for interpretation, and we can see that throughout U.S. history as it expanded its influence. The legislative branch, extremely detailed, providing a lot of restrictions and guidelines for that body, as it was originally one of the most powerful bodies within our federal government. And that, of course, diminishing in ways and expanding in others throughout U.S. history. But let's also explore what our, middle of the road length Article 3 of the U.S. Constitution addresses regarding the judicial branch. So overarching, it addresses the powers of the judicial branch and really has a lot of the inspiration driven by the Federalist Papers. You've had to read many of these Federalist Papers, and many of these judicial branch related Federalist Papers are part of your readings this week. Interesting readings, and without those works advocating for dimensions of this body, we may not have the system we have today. And make sure you go through that, and one of Hamilton's Federalist Papers on the judicial branch is, well, entertaining. It's cool how he advocates for it being the weakest body when he deep down understands that this lifetime appointments and overarching interpretation of the Constitution will eventually result in one of the most powerful bodies within our government. So a unique way of framing this concept in early American history. So when we look at the Constitution itself, what do the 3 sections within Article 3 indicate? Well, Section 1 has the overview of judicial powers, has term limits, which there are none, and salary protections. Well, you're being awfully rude. She is just getting in the way. So we see that this also determines that the judicial power of the United States, quote, shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. We're going to look at some of those examples of, quote, inferior courts as well as the Supreme Court in just a few slides. But we also see Section 2 of the Constitution identifies the jurisdiction of federal courts. This will be important later on, as we will explore. But they say, quote, the judicial power shall extend to all cases, and then it lists an extensive list of circumstances. Continuing, the trial of all crimes except in cases of impeachment shall be by jury, end quote. We'll see how that plays out in just a few slides. Section 3 identifies the definition of treason and limitations on this body. As we always have to emphasize, what does our Constitution do? It defines and restricts our national government. So we see, quote, treason against the United States, and I apologize, it's not going to be this way for you guys, but as I read this, my video is cutting off the end, and I don't remember this by heart. So, treason against the United States shall consist only in levying war against them, or in adhering to the blah, 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 them aid and comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses, blah, 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 overact on or on confession in open courts. Apologies, as I cannot read that perfectly. I don't know how to make the video move while I'm recording. Drives me crazy, but let's keep going. So let's look at that general system. We know they provided the overview of how this system will be structured and gave Congress the power to influence those inferior courts. By inferior courts, we're identifying the U.S. Court of Appeals and the federal district courts. And we'll look at their districts, geographical districts, in just a moment. But it is essential to understand and remember this 3-tiered system, starting locally at the district courts, then circuit courts, the broader regional courts in which if you appeal a prior case, a ruling provided in the district courts, you would then reach the appeals court or the circuit court, often known. And then finally, the most influential court where its decisions are the final law of the land is the Supreme Court. We see there roughly, and they vary from time to time, 890 federal judiciary posts at all levels. And remember, these are some of the 9,000 appointments the president can possibly make in any administration. But also worth noting, these are judges, all of these judges hold lifelong appointments. So you barely see much churn. There is low turnover regarding judges retiring, stepping down, and having president have the ability to appoint new judges, although there are numerous in every administration. Apologies for my dog barking in the background. The dog and cat like to attack each other at the worst times, so we can just ignore that happening. Don't know how to get them to be quieter. So let's keep going. We know that of these 890 federal judiciary posts, 93 courts are representing the district body. This is where we see the majority of our judges, 670 judges, and you'll see one judge per every single case. Say you are charged of a certain offense, this is of a certain federal offense, this is where you would see your case being tried. You would see the judge residing over the case, oftentimes a jury appears, and this is where you would see the trial courts. But if a ruling is provided that you do not align with or agree with, and you think you are due greater justice on some level, you can appeal this ruling. And that's why we see the name appeals court. That's where we also known as the circuit court. You will have in this body a panel of 3 judges residing over every single case. These 3 judges will represent large geographical regions, and there are far fewer judges among the circuit courts. And understanding this, in the entire United States, we only have 13 distinct circuit courts, and I'll show you a map in just a moment. And then finally, if the ruling provided by the circuit court is not representing what you believe our Constitution provides, you can appeal this to the Supreme Court. And the Supreme Court is the final law of the land, the highest court in the land. If they determine that they will hear your case, and they hear very few, roughly 80 a year, as there's only one body for the entire United States with only 9 justices, if they do hear your case, they will provide the conclusive ruling regardless of how it aligns. So here's a more complex visualization of that. And we see that U.S. Supreme Court is always the final leg within our judicial system. We also have military court of appeals. That's where you see certain military related matters start at the second tier of our 3-tiered court system, and then fast tracked to, if relevant, reach the U.S. Court of Appeals for the Armed Forces. There are certain cases, and we'll cover this in just a few slides, in which you will see a fast track to the Supreme Court without going through circuit or district appeals courts, but that is very limited to very distinct cases which our Constitution indicates. We also see various specified appeals or even district courts when it comes to examples like Court of Federal Claims, Veteran Appeals, tax courts, international trade, and things of that general nature. So we will see that numerous issues will go through very complex roadmaps to eventually reach the Supreme Court if they were to obtain that progression throughout our court system. So there is a lot more complexity than a simple 3-tiered system of just district, circuit, and supreme, but we do see that umbrella understanding of the structure which has far more complexity to it if interested in studying in a law course. Now, let's look at those geographical boundaries. This is the circuit of appeals, the appeals court, and where we see if you push back against, you appeal a district court ruling, you would reach these court systems. We reside in the 9th Circuit of Appeal, the 9th District of the Circuit of Appeals. So we see if we try to appeal a district ruling, we can then reach the same Circuit of Appeals court with 3 judges that would reside over all rulings from California, Alaska to Montana. So we see this as a wide-ranging geographical boundary to encompass a broad interpretation of the federal law. This has nothing to do with state laws, exclusively federal law. So let's make sure we understand that distinction between state and federal courts and laws. So the state federal court system. When we look at state systems, one key distinction when it comes to the judicial branch is how we appoint these judges. The state level, we have 2 wide-ranging approaches that are split. We see a little over half of the country using one and the rest using the other. That is either by appointing judges through appointment by the governor or having nonpartisan elections. In the state of Montana, which may be a question on your quiz, we have nonpartisan elections for state judges. Now, it is also very important that we understand that when a state judge interprets the law, they are not relying on interpretation of the federal constitution, but instead the state constitutions and state laws. You see nuanced and unique state legislation and state constitutions for each region. You see, we will look at state constitutions like in Alabama when it comes to civil rights and civil liberties lectures on how they focus on encouraging a moral virtue among their citizens that has been relied upon to use many restrictive civil liberty restrictive legislative policies regarding civil liberties. And we also see Montana, a unique state, a red state that also has sentiments echoing the importance of the right to a clean and, I forget the exact language, but a clean and well-treated environment. That has been the focus of numerous state level Supreme Court interpretations. As it is worth noting, the states also have their own tiered systems of circuit, district, circuit, and Supreme. So the state Supreme Court ruled in the last decade in Montana that we have this right to a clean environment, unique compared to all other states, especially the text of the Constitution, as this dimension with it, which is within our preamble, is not present in nearly any other state constitution or federal constitution. So another form in which states are laboratories for change compared to the federal government. That's the beauty of federalism. We can experiment on the state level, have dimensions of our constitutions that are unique to just us. And throughout history, we will see how that is applied and tested through our judicial system. And then if implemented and protected the correct way, our federal system will use that as an insight to possibly implement on the federal level. The foundational concept behind federalism, present in the United States and abroad. So what is the distinction when it comes to the federal court system? It is important to remember that the federal judges, both in circuit, district, and Supreme, are appointed by the president and approved by the Senate. Remember, that is one of the checks that the legislature has on the executive. So we see appointments made by the president, approved with 2/3 majority in the Senate, and then, simple majority in the Senate, and then we see interpretations of that these judges must rely on being founded exclusively off of federal law and federal constitution. You will not see a state level crime conviction happening in a federal court. They are separate bodies with separate jurisdictions. Think of it as how you would maybe understand local police and highway patrol. They have different jurisdictions in which they focus on different levels of violations. Now, when we also talk about this system at large, it's very important to understand that there are distinctions between civil and criminal cases. There are two different court systems, in a sense, in which address these two different types of cases. Think of criminal as in the state prosecuting you. Civil is you prosecuting another individual. So let's start with criminal. This is where you have the high burden of proof. Innocent until proven guilty. The state must, beyond a reasonable doubt, prove that you have convicted this crime, and then you will be sentenced. It's regarding legal proceedings brought by the government against individuals accused of violating specific laws within state or federal levels. So this can happen within either of those two systems. Think of, what we would always visualize as crimes: murder, theft, assault, any felonious crime in which you are harming another individual. Some level of drug distribution would also be included in a criminal case. Any level of involvement in that world would likely be considered a criminal case. These are the possible outcomes you're looking at, are what you would think traditionally as repercussions in a judicial system: community service, time served, significant fines, probations, fines to be paid to tax dollars. And then we see that this is what we always visualize, the movies, the TV shows of, I forget, SVU or whatever it is. That might not even be right. I think that might be a car type. But whatever it is, we see these criminal cases focused on quite heavily in media, and it's the traditional visualization of what we would see occurring within our judicial system. But our judicial system does far more than that, as it also addresses the needs of citizens in disputes with each other. That is a civil case. This is a legal dispute between individuals or entities regarding rights, liabilities, obligations. Oftentimes, the most frequently used outcome is financial compensation due for one individual over the other. You cannot be punished via sentencing, incarceration, or community service via civil cases. Instead, the outcomes are always monetary. Sometimes you'll see business-related repercussions. They must sell certain dimensions of their company. They must provide certain, compensations or damages. So there are various approaches, but it's all driven. All the repercussions are primarily financial and within our within society, instead of pulling individuals from society into incarceration. So some examples of what you would see in a civil case is breach of contract, family law issues, property disputes, personal injury, personal conflicts. Say your neighbor will not stop parking their car on your grass and it's killed the grass. You would address that in a civil small claims court. So there are wide range of civil cases. One of the best examples I like to use in somewhat contemporary, I'm dating myself a little bit here, contemporary U.S. history, is the O.J. trials of the 1990s. You saw there was a criminal conviction against O.J. Simpson regarding possible murder charges. And we've all seen the famous documentaries, the movies of if the glove don't fit, you must acquit. And we saw that there was a high burden of proof in the criminal court system. He was found not guilty due to that high burden of proof. Now, I mention this because there was a soon after civil case in which the families of the victims of that crime brought a civil case against O.J. Simpson for monetary damages for the loss of the life of their family members. Though in the civil case, he was found guilty and had to pay monetary damages to the families. This is an example I like to point out, as it shows the lower burden of proof and the difference between the two bodies, how one is a criminal case and primarily revolves around incarceration and true punishment for violations of crimes, while civil is violations of, I think you could loosely look at it as rules of the game, in which one may be due monetary damages, and maybe even if it is for a case that is clearly criminal, you can see it brought in a civil case with the repercussions being instead incarceration, monetary damages, if proven with that lower threshold of proof. So we also, before we move on too much, we know the foundations of what our Constitution says about the judicial process, but we also know that we have frequently adjusted this judicial process throughout U.S. history. Most of these adjustments came with our Bill of Rights, representing a time where we're focusing on the civil liberties of individuals. Remember, the Bill of Rights restricts that federal government and protects our state rights. Later, through process of selective incorporation, also protects our individual rights. We'll explore that concept later on in the course. But we see that these amendments regarding our judicial process provide a lot of the roadmap, and let's explore them. First, we see the Fourth Amendment, protection against unreasonable search and seizure. This is your ability to plead the Fourth Amendment and not allow them to maybe search your car, your home, your vehicles, whatever it may be, your private self, your private property. This was highly under scrutiny during the stop and frisk era. You see those policies enacted in the city of New York in the 80s, 90s, and 2000s that resulted in many individuals arguing that their civil liberties were infringed upon, as it violated this 14th Amendment, as there was no established warrants in some cases. We see this as a focus in contemporary debate as well. We see the Fifth Amendment. This is one, if you like comedy or movies and stuff, you probably heard some references. If you're highly involved in the news, you might have heard some references of some individuals pleading the Fifth. What does it mean to plead the Fifth? That's protecting your right from self-incrimination. You do not have to testify against yourself, because we all know that those Miranda rights, I don't know them off the top of my head, but we know that they indicate that you have a right to be silent, and if anything you say can and will be used against you, well, you have the right to not say anything that can and will be used against you. The right to protect yourself from self-incrimination. You can just simply be silent through the judicial process. This does far more than just that, though, as it also protects you from double jeopardy. You cannot be tried for the same crime multiple times. Say the state wants to charge you for murder, but you have shown that you are innocent in the judicial system, the state cannot just go ahead and charge you once again the second that case has concluded. If a ruling has been provided by our judicial system, that ruling is final unless important and relevant data and information comes out at a later date, in which maybe specifically alter the interpretation of the charges or alter the charges altogether. So, Fifth Amendment, you cannot be tried twice, no matter how confident the state may be that you were guilty. We also see the right to due process, the right to stand in front of a judge, the right to have your time in court. It doesn't matter how confident the police agencies are that you have committed that crime. You have the right to testify in front of a judge and go through our judicial system to gain that true representation and not allow the state to be tyrannical and expel you for actions that may not even be objectively proven. We see the Sixth Amendment expands the more nuances of our judicial processes, providing fair and speedy trials. The state cannot incarcerate you for a crime and then say your trial will be in 5 years and you have to be incarcerated until that date. So you have a right to quickly be able to stand in front of a trial and hold a trial. Your right to a public trial, one that can be seen by the public and have access to, even attend in certain circumstances. A right to an impartial jury, a jury of your peers, a jury that is selected through a process that appeals the interests and concerns of both sides of the case. Both defendant and prosecutors have the influence over who the jury is representing. So you can always see a jury is selected by the defendant of the case in many instances, at least jury members. So you do not have, this protects the state from having arguments against its legitimacy, as some may argue that it was a biased jury. Well, it is very hard to obtain a truly biased jury when you have the power to influence who is a part of the jury as a defendant. The right to be informed of charges. When you are being arrested, you have the right to be informed of what you are being arrested for, and so you can adequately prepare your defense for it in courts. Right to confront witnesses. No, you do not have the right to yell at whoever charged you, but the right to engage with them directly and have them testify in the court system. And of course, our right to counsel, which if you were to explore the history of that process, we see there are numerous points in our history where it was not a guarantee that you would have the power to have an individual represent your case, a lawyer defend you. Instead, many individuals without the proper education were left to defend themselves. We also see Seventh Amendment expands that right to a jury to also include federal cases. This is also important regarding the distinction between civil and criminal cases, as it worked out some of those processes. The Eighth Amendment protects individuals from excessive bail, excessive fines, and that famous line, cruel and unusual punishment. If you're an originalist, which we will look at the distinction between originalist interpretation of our Constitution and living constitutionalist, an originalist would say they use the word "and," so that means you can have cruel or unusual punishment as long as it is not both. While a living constitutionalist would say, well, in our modern understanding, cruel or unusual punishment would be unconstitutional, showing the impact of how much you nitpick the specific words or allow the document to be a living and breathing document expressed by that dimension of our Eighth Amendment. Also, we see protections against excessive bail and fines, as one cannot be truly put into bankruptcy due to possible persecutions. We also see the 14th Amendment, a later amendment during the Reconstruction era, came with the 13th, 14th, and 15th Amendments, addressing the issues of the formerly enslaved, abolishing slavery, granting citizenship, and protecting the right to vote. We will look at those when we talk about civil liberties and civil rights, and we will, of course, have to remember them. The 14th Amendment, though, has been heavily relied on in interpretation within our judicial system, providing due process protections for each individual under the equal protection law, and just under those doctrines within the 14th Amendment, which we will explore in detail at a later date. I don't want to overcomplicate this lecture by exploring it just yet, although we do know heavily relied upon within our judicial system, and many of the most recently focused on Supreme Court rulings were provided with the 14th Amendment as a foundation of their interpretation. So, when we looked at judicial appointments, we talked a lot about what this body is, its general makeup, and how some of it operates, but how do we even determine who represents this body? How do we get the chance to maybe even be a judicial appointment? So first, we have to understand that judicial appointments are determined by the president. The president appoints judges with majority approval by Senate. I accidentally said 2/3. It is just a simple majority. And we see the Senate Judiciary Committee holds hearings and debates the merits of individual appointments. We've seen this be a key point in scrutiny under certain presidency in various times in the last decade or so. And we will even we even remember when we talked about the use of the filibuster last week, how it was used so heavily during recent presidency of Barack Obama, that it was used more during his presidency than the entire history prior, and resulted in the nuclear option being utilized to ensure that federal judges, although not Supreme Court judges, but justices, but federal judges can be appointed efficiently. We also know that federal judges and Supreme Court justices hold lifelong appointments. This oftentimes also applies to states, although this is not uniform in every single state. And one unique thing that oftentimes people overestimate is that we have no qualifications, no required qualifications for being appointed a judge or a Supreme Court justice, although we do see long careers within our judicial system as a unspoken de facto requirement. Another example, like the 2-term limit set by George Washington, that we rely on norms so heavily within the United States instead of having solidified laws that ensure these practices. But we know that we respect these norms and ensure that we provide judicial appointments that have a depth of experience within the industry, the world that they will be governing. And although there are no legal requirements for qualifications for being in these offices. So we also know the Supreme Court is the highest court in the land. But let's get a couple overview structural points that we have to make sure we understand for a possible quiz and for being educated citizens. So the Supreme Court has 9 total justices on it. This number has fluctuated a little bit throughout history, as we remember, and I pointed out in last week's lecture, that the legislature has power to determine the apportionment and distribution of federal judges in our federal court system. So how has this changed over time? Well, we see it in its introduction when we had our first Chief Justice, John Jay. Helps you remember the current Chief Justice, John Roberts. In the late 1700s, 1789, 1801 time period, we had just 6 justices on our Supreme Court. We saw that this was problematic at the time, although they had very limited influence in that point of our history. In 1801, the number was increased to 7 because they were tying quite frequently whenever they would address a case. So we had to make sure this was an odd-numbered body to ensure that there were the capacity to break ties. Now this was quickly reduced back to 6 justices and just 2 years later, but did not last for long, as 1819 came and when the court grew to 7 once again. And this was all led by the legislative branch, to remind you. We do see this was emphasized as we saw a form of stacking of the courts in the year 1837, as the number of justices led by the legislature increased to 9 justices, what we have today. But of course, we did not immediately go to that number and accept it. 1863 came and the court reached 10 justices, but it was very short-lived, and just a few years later in 69, the number of justices was permanently set to 9, where it has remained ever since. We see that this has been discussed as a theoretical debate regarding the concept of stacking the courts, although it has not been considered by the legislature in recent decades. So the current Chief Justice of our Supreme Court view this as the head of the Supreme Court. They have significantly expanded powers, although not as extensive as, say, the Speaker of the House over the House of Representatives. They have increased powers over the body at large. We'll explore those powers in just a moment. But we do remember that we have this system, this court system that stands among the entire 3-tiered judicial system. Any ruling provided by the U.S. court system will be the final law of the land. Although it is important to make this distinction that they have no enforcement powers, and they rely on the respect of the 3 branches of government for those legislatures and executive powers to rely on the interpretation provided by this body and govern accordingly. Like, for example, when we saw rulings provided in Brown v. Board of Education, there was required legislation to come to ensure that the implementation of that interpretation was done effectively and that the legal code of the United States reflected such interpretations. But they do not have their own enforcement mechanisms. And this has resulted in very, very few instances. We think of Andrew Jackson starting the Trail of Tears instance in U.S. history, where the presidency and the court system were in conflict with each other. And we do see U.S. history has indicated the president won that conflict out, but the U.S. court system has provided a legitimate interpretation of our legal code that has persisted for many years. And the time of Andrew Jackson was a long, long time ago. We also know the U.S. Supreme Court hears about 80 cases a year, although this fluctuates and depends on what they agree to consider. So again, I mentioned this a second ago, but what are the requirements to becoming a Supreme Court justice? There are none. That doesn't require a law degree or maintenance of certain age. You could be a 5-year-old and be appointed to the Supreme Court if the president so feels it. So, understand the degree in which we rely on the norms of executive and federal actions to ensure the effectiveness of this body. So there are no requirements. They hold lifelong appointments, some of the only bodies within our government that hold such extensive lifelong appointments, and they are, of course, as we know, appointed by the president. When we look at the Supreme Court, we remember the first Supreme Court was created by George Washington, and the man known for establishing precedent in the United States. So when we look at what he determined as requirements for appointing these justices, he thought that you could easily identify 7 requirements for having been an appointment to our Supreme Court. These 7 requirements utilized by George Washington included support and advocacy of the U.S. Constitution, as that is the guiding document of this governing body, distinguished service in the American Revolution. It'd be hard to maintain that one today, and that is distinguished service militarily or politically, as operating as penmen or as gunmen at the time. We also know active participation in the political life of a particular state or the nation as a whole. States are laboratories for change. You have to have experimented in your state laboratory to ever engage in the federal Supreme Court. Think of it simply in that format. We also know prior judicial experience on lower tribunals, so this cannot be a fast-tracked partisan or political body, although that was not much of a focus at the time. We do see the acknowledgement that this is a end result of a career in this system. And you must have either a favorable reputation with his fellows or personally known to Washington himself, representing the reality of a lot of things we have dissatisfaction for within the private lives and private companies and within federal government, that you got to know people to be considered, although there are many opportunities within merit-based positions to submit applications when you know nobody. But there is a reality that when it comes to appointments, you have to be favorable reputation among his fellows or known by him yourself. We also have to know that at the time, you had to be geographically suitable. The original Supreme Court were circuit riders. They had to be regionally located, and it was important that they were in a region where they could actually engage productively. And finally, the poetic side of it. Got to have love for the country, or you can't represent the country that you love. So let's talk about the Chief Justice of the Supreme Court. We already know it's John Roberts. They have a little bit more influence and power over the overarching body, but let's talk about those powers specifically. So we know that this Chief Justice is a single justice with heightened leadership responsibilities. These responsibilities include presiding over impeachment and traditional court hearings. So remember, if you saw that State of the Union, you saw the Speaker of the House and the Vice President standing behind the President. Think of the Chief Justice in any Supreme Court hearing residing right there on the top of the podium, basically sitting where the President would be. Weird comparison, but if you saw it, it's a visualization to help out. We also see the Chief Justice leads private conferences among justices, significantly influencing the form of debate that occurs among the justices behind closed doors, where they truly debate the merits behind each case. We also see, and this is how all cases are heard, there will be private conferences among the justices in all cases reaching the Supreme Court. We also see the Chief Justice has slightly increased influence over creating the discuss list, which determines which cases the justices will vote on to be heard in the next year or so, in the following months. And we do know the overarching rule is if 4 justices vote to hear a case, it will be heard by the body. although the Chief Justice creates that discuss list I mentioned that proposes that really sparks the discussion on what cases will be heard, as it is a list of cases to be proposed that the Chief Justice identifies as having some level of merit. We also see the Chief Justice of the Supreme Court is the head of numerous committees and judicial bodies, significantly influencing interpretation and governing mechanisms within those committees. Now, when we briefly mentioned this a second ago, it's one of the powers of the Chief Justice that they have a little increased influence over the cases that are reaching the Supreme Court. Well, there's two distinctions we have to make here. There's original jurisdiction and appellate jurisdiction. Original jurisdiction is something I mentioned earlier. It can fast track the three-tiered judicial system. And instead we can see, and this applies to cases involving disputes between states and cases involving ambassadors or foreign countries. So think of it as a case that doesn't have a clear starting point within our circuit or district courts, but immediately, as on its onset, relates to the national issues within government. We've seen this in recent years past, as we've seen a fast-track case brought to the Supreme Court relating to federal executive immunities for actions in or outside of office. It's a nuanced debate to be had for a later date, but that's one example in recent years. We also see appellate jurisdictions. That's where the rule of 4 comes. That states that a case will be heard if 4 justices agree to grant what is known as certiorari. I can't even pronounce it. Go easy on me. Public Southern education here. That is a simple petition to be heard by the court. You see that for writ for a certiorari petition for cases to be heard by the Supreme Court, oftentimes having to previously reach the district and circuit courts. They have roughly 7,000 to 8,000 petitions every single year and only consider about 60 to 80 cases each given year. So high level of scrutiny about which of these petitions are granted for a hearing in the Supreme Court. Now, how does the Supreme Court provide a ruling on these cases that it has now agreed to interpret? So first, that process we just discussed, the petition for writ of, I'm not even going to try again, in which the Supreme Court receives, I put the average in there, about 7,500, but 7,000 to 8,000 petitions each year, and here's only 60 to 80. And you need 4 justices to support the hearing of a case with added influence to the Chief Justice as they create that discuss list that sparks the discussion. We also see the second stage of a Supreme Court ruling is that there are hearings scheduled. There are private and open hearings for the Supreme Court, both for defendants and prosecutors within that system, to present their oral arguments. So oral arguments are heard from both sides, and then you will see the private conferences among the justices. This is where you see this led by the Chief Justice and debates among the various sects within the 9 individuals among the body. And this will result in the Chief Justice assigning the majority opinion to one of the justices, oftentimes providing the majority opinion themselves, majority opinion being the overarching ruling, say 9 justices, you have 6 to 3, and the ruling was in favor of the case brought forward. Well, the Chief Justice, if they are among the 6 voting for, they are likely to provide the majority opinion, which is, loosely speaking, a paragraph explaining why the opinion was provided, what foundations they relied on. Now, there are dissenting opinions that are provided by those 3 that might have voted in opposition to a certain ruling. And that is where you see the published and openly accessible, publicly accessible majority and dissenting opinions provided. We have seen majority and dissenting opinions come with nearly every ruling in U.S. history, and looking back at some of those dissenting opinions and majority opinions throughout U.S. history reveals the sentiment and pushback against certain actions, especially when we look at Plessy v. Ferguson in U.S. history, as we see the dissenting opinion focusing on the role of race in the United States. So let's talk about landmark rulings. What are landmark rulings? Well, a ruling that substantially changes the interpretation of existing law that's provided by our Supreme Court is known as a landmark ruling. One of the best ways to understand what a landmark ruling is understanding that it establishes a standard or test to be utilized by lower courts in the future. It'll define constitutional rights. It'll provide a roadmap for understanding what our constitutional rights are in any given instance. We see one example of this being the Lemon Test in U.S. history, which we will explore in just a few slides, as it was a landmark ruling of the 1970s that provided a test to determine the excessive intermingling of church and state, but was later dismantled in 2022 off of excessive interpretations under certain circumstances. So this oftentimes results in shifts in social and political values and power and influence in society. We see another great example, Brown v. Board of Education, visualized in this photo here on this slide, as it significantly impacted the way public education was addressed among the entirety of the United States. So, how do we interpret our Constitution? We know that there is a clear process for providing rulings and many of the nuances and general structures, but we also know that there are different approaches to every job that exists. And when it comes to interpreting our Constitution, there are two distinct approaches that can be summarized by the actions of recent and historical justices. It is also worth noting that this is not partisanship. Now, we have partisan presidents appointing justices, but even when we have what our political scientists today refer to as a conservative Supreme Court, we will not see justices vote along party lines aligning with Democrat or Republican sentiments, as they stand separate from the system, as the hope and intention of this body is to be a non-ideological and non-partisan body, exclusively using the Constitution as their ideological text, I guess you could say. So, how do they differ when they read that text? Well, you will either see originalism or living constitutionalism. Now, what does an originalist say about our Constitution? Well, they say that our Constitution was written a very specific way. And when our founding fathers wrote that guiding document, they chose every word with precision and intention. Yes, they chose the word end in that Eighth Amendment when they said there will be no cruel and unusual punishment, knowing that there may be cruel or there may be unusual punishment, is what the most hardline originalist interpretation would maybe argue. Now, on the other hand, a living constitutionalist is one who says our Constitution, no matter how specifically each word was chosen, cannot represent every generation. And this Constitution must live and breathe with the changes of society. So we must change how we interpret certain words within our Constitution to reflect the society that lives today. Using that Eighth Amendment example, we would see a living constitutionalist say, cruel and unusual punishment is bad and unconstitutional when it is cruel or unusual, not when it is just both. So they would say either would be unconstitutional when you consider the development of society over time. So we see this significantly impacting how they provide certain rulings, more so than partisanship in many instances. We see this being best represented through the case of the District of Columbia versus Heller, a Supreme Court case relating to individual gun ownership rights within Washington, D.C. We will explore that in a few slides in detail, but we do see that originalism is represented in the majority ruling, as they used 1800 text to defend the identified original intent behind a well-regulated militia, and they also provided protections for gun ownership and personal self-defense as a constitutional protection in their majority ruling. Now, we also saw the minority ruling represented that living constitutionalist perspective, and they focused on the development of contemporary societal challenges and emphasized the value of gun violence data points, and argued that we must regulate this militia within the United States. So let's continue on, and we will revisit this distinction, especially when we look at District of Columbia versus Heller and the 2008 ruling that was provided. But make sure you understand the difference in approaches. Originalist, specifically nitpicking the every word of the text. Living constitutionalist would put more value in contemporary data points like gun violence data. So I mentioned this previously. And, we have to acknowledge it when we're making the distinction about what drives certain rulings. Is it conservative and liberal, or is it original and living constitutionalist? Well, this course identifies that there are much more data points that we can see that our Supreme Court is governed by originalism or living constitutionalism, although there is influence of partisanship throughout history. We see, visiting back to the 1970s, when we saw the rulings that we are revisiting in recent years provided, we saw a majority liberal Supreme Court. Our political scientists were identifying it, our historical textbooks still identify that as what was happening at the time period. The expansion of many civil liberties through legislation, not legislation, but through Supreme Court rulings regarding the expansion of civil rights in Brown v. Board of Education, the expansion of individual bodily autonomy through Roe v. Wade. We also see Lemon v. Kurtzman providing distinctions between church and state. So a liberal wave of interpretations provided by the Supreme Court. We saw that is it being pushed back against, and some would say, as we are revisiting a lot of those specific rulings in our contemporary Supreme Court, which political scientists identify as a conservative Supreme Court. Still, we prioritize the distinction between originalism and living constitutionalism when it comes to the actions of our justices, but it is worth having this discussion here. So, we can see measured increase in rulings favoring conservative ideologies in recent years, and we see that there are 9 justices, 6 currently appointed by recent Republican presidents, 3 from recent Democratic presidents. That alone should not have much influence and much sway in how we study and examine the Supreme Court. But we do know when we look at the recent voting records of our Supreme Court, we've seen alliances within these partisan appointment lines. 6 of 9 justices were appointed by Republican presidents and are measured to be roughly 10% more likely to provide rulings favoring conservative policies. This is a higher rate of aligning with partisan sentiments than we have seen in history, in U.S. history. So we also see that when conservative policies are defined as pro-state, and that is exclusively when conservative policies are defined as pro-states, pro-restraint of judicial power, anti-environmental protections, anti-union, pro-rule of law, and security over liberty. So there's a clear distinction in that study that was enacted on what it means to provide rulings favoring conservative policies. I wanted to make that distinction clear, as this was not simply, party line sentiments. It is this study was done with an attempt to define conservative and liberal and then examine the extent in which these sentiments are represented in certain rulings. So, detachment from individuals, attachment to ideologies to study this dimension. So when we look at our current Supreme Court, we identify the conservative wing of the Supreme Court. I also provided the initials of the president who appointed them. I think we can piece together who the president was based on the initials alone. So we see Chief Justice John Roberts, George H.W. Bush appointment. He is the current Chief Justice, George H.W. Bush, Republican and president of the past. We see the longest standing, one of the most influential, long-standing justices, Justice Clarence Thomas, George W. Bush, not the longest standing. We also see Justice Samuel Alito, George W. Bush appointment, and Justice Neil Gorsuch, Justice Brett Kavanaugh, and Justice Amy Coney Barrett. All 3 were Donald Trump appointments in his first term as president. We also see the liberal wing of Supreme Court justices, including Justice Sonia Sotomayor, Barack Obama's appointment, alongside additionally Justice Elena Kagan and Justice Ketanji Brown Jackson, one of the most recent appointments to the Supreme Court, appointed by President Joe Biden, his only appointment to the Supreme Court. So, let's talk about some landmark rulings. Like my little photo I had ChatGPT make for me, lemon test no longer exists. It's crossed out. It's kind of ridiculous. But let's talk about what the lemon test is. So the lemon test, when we look at it on a general umbrella understanding, it is addressing the separation of church and state by providing clear standards. Lemon v. Kurtzman provided a ruling that there will be a lemon test implemented in all lower inferior court's rulings. This lemon test will determine the intermingling of church and state by asking 3 questions. Any court addressing an issue of church and state should simply ask 3 questions to fast-track their capacity to interpret the case. The first question should be, does the law have a secular purpose? if it does not have a secular purpose, it simply does not pass the Lemon test and should not be implemented, as it will represent excessive entanglement. The second law, the second question, does the law's primary purpose inhibit religion by prioritizing one or dismissing all religions? Any prioritization of one religion will inhibit other religions inherently. So we cannot give more power to one over others. The third test question, the government must not be excessively entangled. Is the government engaging with this religious institution frequently? Are they giving them benefits that exceed those provided to other religious institutions or other civil society collectives? So we see this rule was provided because, well, this was driven by private school funding. Originally challenged a Rhode Island statute that provided salary supplements to private schools, but when you looked at the data on how that funding was being distributed, 95% of the supplemental salaries were being provided to Catholic schools. These teachers receiving government supplements were teaching private Catholic schools and not teaching public school education. And that was a key issue in how and what brought forward the Lemon v. Kurtzman trial. We see that this later resulted in the ruling that did implement the system, but it was later overturned in a ruling provided by Kennedy v. Bremerton School District that overturned the Lemon test in 2022, and providing a ruling from the originalist collective that somewhat contradicts originalist interpretation, showing that this is a nuanced reality when it comes to each individual case, and many of these roadmaps for an understanding approaches to governance are general starting points, and they of course deviate here and there, as we see the majority ruling provided by the originalist sect of the Supreme Court in 2022 stated that history tradition provides the scope of constitutional rights, end quote. So that kind of sidestepped some of those originalist dimensions and relied on modern and historical tradition and scope. So what happened in Kennedy versus Bremerton School District? Well, this was a case where there was I believe it was a football coach, and this football coach had a tendency, and before and after every football game, to go out on the middle of the field exclusively by themselves, kneel and pray for good luck and for thank you for the game. This was viewed with scrutiny by some parents and some individuals within the community who said he should not be able to pray with such an open show of an event when representing the public school. Well, they said that since he did it individually, and there was far more nuance to this, I'm simplifying this, but individually it was an expression of their their First Amendment rights instead of actions representing the institution of the school, the public school themselves. So they say that if you relied on the Lemon test when interpreting the Kennedy versus Bremerton School District, there would be a level of, well, there would be no secular purpose for the action. It would inhibit other religions as it prioritizes the religion that he is representing, and it could represent excessive entanglement because a public school representative is engaging in religious practices in public at a public school sponsored event. So the Lemon test would reveal that this was an act that he should not be allowed to engage in. Well, the interpretation in 2022 stated that this should be a legally protected activity and dismantled the use of the Lemon test in later courts. This was a landmark ruling because it dismantled the implementation of the Lemon test and later impacted later interpretations. Now, Roe v. Wade. Another important distinction that we have to make is that this has been addressed in two distinct cases, although there are quite more. And what we're going to do in today's lecture is examine the constitutional foundations relied on in both of these rulings and how they represent landmark rulings. So we know that Roe v. Wade, originally in the 1970s, was founded off of the 14th Amendment. The 14th Amendment's dimension that states, quote, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the law." So we see that was emphasized that there was protections for due process, which protects certain fundamental rights from government interference, even if procedural protections are in place. So they argue that these substantive due process protections expand into protections for individual privacy and bodily autonomy. We see that the U.S. Constitution provides a fundamental right to privacy that protects a woman's liberty to choose whether to have an abortion, relying on that 14th Amendment due process clause. That was the provided ruling by our Supreme Court. This was they attempted to provide federal protections for privacy and healthcare via this ruling, and ruling focuses on the protection of liberties under the due process clause. So if there were as we look at throughout, as we rewind to the beginning of the course and remember that conflict between liberty and security, we would see the ruling in Roe v. Wade as a prioritization of individual liberties and a dismissal of security in certain instances. So we see this ruling has been overturned, just as Lemon v. Kurtzman has been overturned. And the only way to overturn a ruling is via a Supreme Court ruling. No executive or legislative action can overturn a Supreme Court ruling. And that is a very important distinction to make. Only they themselves can overturn previous historical rulings. So we see those two pictures at the bottom representing the two distinct time periods in which we address this issue. And the one to the right is where we see the traction that resulted in the overturning via Dobbs v. Jackson. This was arguing that the Constitution of the United States does not provide a clear and direct right to privacy, and that abortion is currently a states' rights issue. This had a result of bringing this to the capacity to govern this issue to the states, as now we have no federal legislation or interpretation of legislation addressing the issue of women's bodily autonomy at this time. This is due to the overturning of Roe v. Wade, which shows how it is a landmark ruling, changing how lower courts and state governments will interpret the law. One of the arguments within the overturning of Dobbs v. Jackson is that although there are many dimensions of privacy within our Constitution, it does not transfer to this specific instance. When we look at privacy within our Constitution, and specifically our Bill of Rights, I think it's beneficial to have a brief discussion that addresses to what extent is it covered. So our First Amendment addresses the right to privacy of beliefs and privacy of group membership. The Third Amendment addresses the right to privacy of the home. Housing Soldiers Amendment. We'll see the Fourth Amendment, protection against unreasonable searches. This is your right to be secure in your persons, houses, papers, and effects. Many would argue that this, including your security and privacy within your persons, could be expanded for interpretation in that dimension. We also continue and understand that the Fifth Amendment has a right to privacy and personal thoughts and documents, protecting individuals once more. We see, your right to protection from incriminating against yourself. Your personal thoughts can be your personal thoughts. Ninth Amendment, protection of rights not granted to the Constitution are left up to the states and the people. So your right to privacy in this instance, if it is not addressed by the Constitution of the federal government, will be a right of the state. And if it is not addressed by the state, it is a right of the person to address. This amendment says, quote, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. We also know the 14th Amendment, protection and privacy of personal freedoms. Now that is what has been expanded and interpreted to rely on in the Roe v. Wade ruling, as it says, quote, deprive any person of life, liberty, or property without due process of law is unconstitutional. Well, they would argue that original interpretations of certain restrictions on this act at the time fell under that umbrella. We see that the dimension of the 14th Amendment that was relied on is the due process clause, which protects certain fundamental rights, including privacy from government interference, particularly through the doctrine of substantive of due process. And we see that broad interpretation of including privacy, but not specifying what form of privacy, allowing the interpretation in the 1970s from our Supreme Court regarding the Roe v. Wade ruling. We do see that these are not the only cases that address these issues. We see Griswold versus Connecticut, and if we had the time, I would explore that in detail, but I do not want to go excessively into detail and distract from some of the main takeaways we should have here, which is what the constitutional grounds were for each of these rulings, and how and why we look at them as landmark rulings, as they had significant impacts in how states and the federal government govern individual lives. And we see some could argue this is a prioritization of liberty over security in U.S. history, with a recent revisitation prioritizing security over liberty in Dobbs v. Jackson. So, Now we're really rewinding a bit throughout U.S. history, and we're going to look at Plessy v. Ferguson, an 1896 Supreme Court ruling, which has, as you may be noticing a trend, has been overturned, like the three other previous rulings explored. The two other previous rulings. So, what did Plessy v. Ferguson do? It established constitutional segregation through separate but equal doctrines. So we see that this sparked the Jim Crow era of legislation and legitimized segregation in numerous dimensions of the United States. Now, what dimension of the United States civil life sparked this debate to begin with? Well, we have to remember that this was not just a clear example of inequalities that was just focused on. This took purposeful mobilization and organization. An individual by the name of Homer Plessy was an activist. He was, in the general public, known as white passing. He was 1/8 black. He would be segregated from accessing certain institutions if there was knowledge that he was black, although he was able to pass as a white man at certain times. So this enabled him to ride in the white railway cars at the time. There was a separate railway car, I think it was a separate car act of 1890, which legitimized the segregation of railway cars, a key form of transportation at the time. Now, this individual, Homer Plessy, knew that he could simply ride in the white railway cars, but knew that this was not an acceptable policy within the United States, and it is unconstitutional on a simple taste test. Well, Homer Plessy decided to notify the railway car that he is indeed a black American citizen and that he will be on the white railway car, purposefully being arrested for this act so that he could eventually bring this case to our court system. So we saw Homer Plessy was arrested as he sat on that railway car, and then the process began. We see the process as it moved through the judicial court system and eventually reached our Supreme Court. And that is when we saw our 1896 ruling, which determined, in opposition to what Homer Plessy thought was so clear, that separate but equal will indeed be equal, at least for the next few years. We know that segregation ended 59 years, well, not 59 years ago at this point. I need to change that in the slide. And what is the math? Yeah, whatever the math is 2026 now. And segregation ended in 1969. And sometimes I just like to point out, just to put it into perspective, how recent a lot of these developments have actually been. There was segregation protected for 70 years, and we've gone a shorter time without it than we have gone in the United States, institutionally protecting it with Supreme Court interpretation. So there's a bit of a unique history as we examine the reality of this, and we consider the fact that our 8-body Supreme Court at the time had a 7-1 ruling, with one justice ruling against it. This justice goes by the name John Marshall Harlan, and in his dissent opinion, he said, quote, "The white race deems itself to be the dominant race in this country," end quote, and later referred to the Constitution as instead colorblind. So focusing on the reality that this is unconstitutional, and he will be joined later in life in the year 1954 by a Supreme Court which rules in favor of Brown v. Board of Education and overturns Plessy v. Ferguson and determines that separate is inherently not equal. So we see we've protected segregation in this country longer than we've gone without it. And a quick personal example to help illustrate that this is far closer to U.S. history, contemporary history, than we may perceive, than it may feel. My dad, born in 1960, born in Brooklyn, New York, so he was okay. But say he was born in the same county I was born later on in life, in Virginia, rural counties of Virginia. In 1965, that same county shut down its public schools for 5 years in protest against the desegregation of public schools, representing a collective in this country that would rather have their children go without public education than to allow them to be publicly educated alongside members of another race. My dad would have gone from the age of 5 to 10 years old without access to public education if he was born where I was born, due to the issue of segregation in the United States. So, just a little bit of a moment to remember the power of the Supreme Court, the power of landmark rulings, and the constant fight throughout U.S. history for civil liberties of numerous collectives, and how recent these fights have actually occurred. Talking about that topic, let's continue to very recent history and the expansion of the civil liberties and civil rights of another group that is presented in the ruling Obergefell v. Hodges. Now, it is important to know that Obergefell v. Hodges is the first primary Supreme Court case we will be examining so far in this lecture that has not been overturned. Not been overturned. That may be a question. Which of these cases has not been overturned? I may have a list. Make sure you remember which ones are currently landmark rulings and which ones have been overruled by more recent Supreme Court rulings. So, what is Obergefell v. Hodges? This was a landmark decision of the Supreme Court of the United States, which ruled that the fundamental right to marriage is guaranteed to all couples, regardless of sex. So we see this relied once again on that due process clause and the equal protection clause of the 14th Amendment. But it was not a unanimous decision. It was a 5-4 decision, and immediately overturned numerous bans on same-sex marriage in 13 different states. Particularly, there was a heavy attention towards some cases in Texas, as there was various high levels of restrictions on individual liberties within the state. When we look at the rulings from this most recent Supreme Court ruling, prior to the contemporary conservative Supreme Court, we see the majority ruling provided by Justice Kennedy, who is no longer residing on the Supreme Court, that, quote, the Constitution promises liberty to all, and he continues on to define and express their identity, end quote. We also see the dissenting opinion coming from our current Chief Justice John Roberts, arguing, as you can read it, although the policy argument for extending marriage to same-sex couples may be compelling, the legal argument for requiring the extensions are not. So, pushing back against some of the foundational arguments that the majority ruling relied on were present in the 14th Amendment. So what even happened with Obergefell v. Hodges? Why did we get to see this case? Well, it's been a while since I've looked at all the specifics of it, but an individual by the name of, I believe it was Obergefell, he was married to an individual of the same sex, but they lived in a state where their marriage was not legally recognized. They had to travel to an external state to get their marriage license. When they returned to their home state, sadly, relatively soon, the husband discovered that they were terminally ill. The husband passed away just a few months later. And on the husband's death certificate, it was identified that he was not married because it was not legally recognized in the state. Now this, beyond a moral sentiment that just is simply viewed as a bad taste in the mouth of the husband who does not have their spouse recognized by the state, also significantly impacted the financial aspects of financial challenges of what comes with passing away when you have marriage and dependence as a factor. So Obergefell petitioned for this case to reach the Supreme Court, arguing that we have a legitimate marriage license within these United States. We are a legally married couple and deserve to be recognized by the state government they live in, especially when it comes to the memory of his late husband. The ruling provided them these guaranteed rights. In the year 2015, the fight for civil liberties and civil rights, no matter perspective and opinions, is ongoing, and it likely will continue to persist our entire lives. Again, this was not the only case addressing these issues. There were numerous legislative acts. Think of the Religious Freedom Restoration Act, which provided high levels of restrictions for equal marriage rights in numerous states. Think of the Supreme Court cases the lower court cases in Lawrence v. Texas, a 2003 case, United States versus Windsor, 2013 case, and just know that this is an ongoing challenge, and our most recent landmark ruling is present via Obergefell versus Hodges, as we presented and protected the fundamental right to marriage for all. Citizens United. As you've maybe noticed, a trend of somewhat inflammatory landmark rulings being focused on. Well, because these are some of the most impactful. These are some of the starting points that you already understand that enable us to explore in detail. So what is Citizens United? This is a nonprofit group aimed to air films against Hillary Clinton's campaign in the 2010-2008 campaign when she was running in the primary against Barack Obama for the presidency. She lost the primary, worth noting. The conclusion of the ruling in Citizens United 2010, this was also heard in late 2009, so you'll see like the trials of 2009 Citizens United, the ruling of 2010 Citizens United, same thing. So the conclusion, regulation on money and politics is equivalent to regulation on free speech. Now, this was because they were arguing that you cannot regulate a corporation's capacity of free speech. Corporations are equal to individuals expressing free speech, and you limit the amount they can spend on money, spend via money in politics, you're limiting the corporation's free speech in politics. This has been a focus of many of the general population in favor of disfavoring. There's a wide range of interpretations, but what we're focusing on today is the simple impact of this ruling. So what did this ruling do? It established the legitimate creation of what are referred to as super PACs, super political action committees. And one of the downstream repercussions is the rapid increase in money spent on politics, specifically national political party elections, presidential elections, and various legislative elections. So what is a super PAC? Well, one, a political action committee is a committee that is organized to advocate for certain candidates or for certain policy initiatives. Now, a traditional political action committee has high levels of regulation about how much they can take in from an individual and how much they can spend on various other issues. Now, they have a little bit more ability to spend money on candidates, give money directly to candidates, although every dollar they receive has to be tracked and attributed to an individual or corporation on some level. So there's detailed record keeping on how you can contribute money, who contributed the money, and there are caps on how much money can be contributed to a political action committee. A super PAC, on the other hand, changes those rules and regulations. They can have unlimited contributions, and they can obtain those funds from private individuals. But when it comes to spending those funds, super PACs have higher levels of regulation. They cannot give funds directly to campaigns, they cannot fund a candidate directly, and they cannot work with a campaign to ensure that they have uniform messaging. But what a super PAC can do, say they are focused on an initiative that is clearly along partisan lines, they can put out ads or attack ads focusing on a policy initiative. And we see numerous super PACs influencing Montana elections through public media ads, focusing on various impacts. I don't want to specify any single one, but we do know that they are present every electoral cycle. So a super PAC can receive unlimited amounts of money from corporations, unions, and groups, cannot directly interact with campaigns, and cannot directly fund a campaign, but they have a power to spend money quite significantly. The impact of this expansion of, the impact of creating super PACs and expanding the way we interpret the spending of money in politics changed the amount of money spent in politics, rationally so. We can look at the 2008 presidential election, and we see that roughly $1.7 billion was spent. And we know 2008 was right around the corner. Maybe some of y'all were born around then, that's crazy. But we see that in just that limited amount of time, when we were singing from 2008 to 2008, thank you, Fergie, we also see that we were increasing the spending we put towards presidential elections up to $6.6 billion in 2020, exponentially increasing the amount of money spent on national politics after the ruling provided by Citizens United. A fast-tracked expansion that was not replicated in years prior when we look at rates of increases, number of dollars in political campaigns. When we look at the textbook, one of the arguments of the textbook states the main beneficiaries of these new rules were not corporations, but instead ideological interest groups that were often funded by extremely wealthy individuals. End quote. So we see that many political scientists argue that this expanded the role of the wealthy classes among the United States in their ability to influence political elections. Now, the final Supreme Court case to be examined in this course, which we will go through quickly because I know we're going well over with time, is the case I previously mentioned that provides a distinction between originalism and living constitutionalism. That is the District of Columbia versus Heller case, in which the Supreme Court provided a ruling regarding private gun ownership in the name of self-defense. Now, the simplified and quick storyline that occurred here is that Washington, D.C. enacted some highly restrictive gun rights legislation within their city limits in response to the high rates of crime that was occurring in the early 2000s and 90s, violent crime in particular. So one of these legislations was the restriction of private gun ownership and restricted one's right to own a loaded handgun in public or carry a handgun in public. So it dismantled the individual right to own and carry firearms, and we see that this was pushed back against in this case, District of Columbia versus Heller, as a local police officer in the city of D.C. had a personal firearm. And when they were at home, they were legally not allowed to have this firearm outside of a safe, but they were legally permitted to have a firearm on duty. This contradiction was something that sparked this individual to bring this case to the court system and eventually resulted in it being heard by the Supreme Court. And then this case became a debate, and I wish we had more time to explore this, but it became a debate around individual right to own and carry firearms or a collective right tied to state militias to own and carry firearms. Now we see this debate persisting to recent days, although we see the individual right argument in many senses winning out in the end. As we saw, the ruling provided that the individual was licensed to hold and to obtain a firearm in his own home, and any regulations on this would be a violation of the Second Amendment rights presented to this individual. So we do know that this case was quickly addressed within our court system, and we do see general arguments for the majority ruling, being that the term militia in the 18th century referred to all able-bodied men who were expected to bring their own weapons, important own weapons for military service, indicating that individuals had the right to own firearms. They, in their rulings, advocacy for the ruling in favor of District of Columbia versus Heller relied on a lot of 1800 texts specifically emphasizing this sentiment at the time. There was also the National Rifle Association, the NRA, which was founded in 1871 as a marksman organization that was increasingly focused on protecting individual gun rights. And by the 1970s, the NRA shifted to a much more aggressive stance against gun control, arguing that the Second Amendment protected an individual right to own and use firearms for self-defense, bringing that shift and framing into the grand scheme, into the general zeitgeist. And this ideological shift was driven primarily by concerns over government overreach and a belief in self-defense, and resulted in a lot of these sentiments we see echoed today. The court in the end held that because the framers understood the right of self-defense to be the central component of the right to keep and bear arms, the Second Amendment implicitly protects the right to use arms in defense of hearth and home. So we see the relying on not the right to bear arms dimension of our Second Amendment, but the regulated militia dimension that ensured that we all had, which if we rewind to early American history, we remember that we didn't have militias. We didn't have national or state armies. Instead, we relied on well-regulated, individually armed militias to protect the United States, which we remember was problematic, especially when we look at Shays' Rebellion and various other instances, even the Whiskey Rebellion, which was more effective in U.S. history. But we do see the main takeaway from this ruling is that it is the current interpretation. It is a landmark ruling that still persists today. It reveals the divide between originalists and living constitutionalists and addresses private gun ownership. Now, I will not spend too much time on this, as we are well over our ideal 1 hour time period on the week's lecture. So I recommend you pause this slide and you look at the legislative actions and judicial actions regarding gun regulation in recent U.S. history, and how this has been an ebb and flow issue with various points and various pieces of legislative code and interpretations significantly impacting how we regulate our firearms, and to present and reveal that this is an ongoing debate just like many of the issues addressed today, but what we rely on is the debates held within our judicial system. So, quick review. Different approaches to interpret. Originalists. We remember that 5-4 ruling favoring originalism in the previous Supreme Court ruling examined. The people refers to the individual, not just the militia members. They really rely on a lot of 18th century historical sources and texts, but using these texts, they were able to dismiss relevance of contemporary data points like crime rates and public safety measures. Our Constitution and what it meant when it talked about our well-regulated militias is what should be interpreted when it comes to our judicial branch, the Supreme Court's interpretations. Another quote presenting this sentiment was provided by Justice Scalia, once again, another justice who is no longer with us, as he said, quote, constitutional rights are enshrined with the scope they were understood to have when the people adopted them. End quote. Focusing on that, we should not be adjusting interpretation due to developing threats, but instead rely on the interpretations provided when they were written. We see in contrast to this, the living constitutionalism argument argues that DC's regulations were reasonable regulations of individual rights because they were addressing rapid increases of gun violence in the city. They applied means and scrutiny, which if you were looking at how judicial branch interprets generally, one of the key terms, weighing individual rights with public safety. It is important to have individual right protections, but to what extent does this infringe upon the state's ability to ensure public safety? That should be considered in Supreme Court decisions. We also see they argue that courts should consider contemporary consequences, death rates, gun violence, public security measures, just general data on gun violence and general violence at the time when considering these issues instead of 1800 text regarding sentiments and hopes and desires of our founding fathers. We see a quote that I will not even try and read by Justice Breyer, another justice who is no longer with us, presenting the living constitutionalist sentiment in this quote on the ruling of Washington, D.C. versus Heller. So, how do we check the judicial branch? Well, the executive has some powers. For one, they appoint the judges who run the judicial branch. We see in recent years significant impact led by the executive, as we've seen one president appoint 3 justices. Worth noting, this has happened numerous times in U.S. history. Not a issue or anything, just shows the extent of influence from the executive body. We also see that the president can grant pardons, reprieves, and commutations, overriding rulings provided within our federal court system, so ensuring the freedom of individuals even when our court system argues against. We see our legislative body approves judge appointments within the Senate. They have to be approved by our Senate or they will not be a judge. Significant oversight over the judicial branch. We also see they draft the legislation that the courts must interpret. They don't just exclusively interpret the U.S. Constitution, but also statutory code when it applies, especially when we look at instances like Washington, D.C. versus Heller. In that case, did rely on some regional and recent legislation led by the legislature. We also see that it determines the number of judges on the Supreme Court. We talked about that ebb and flow through U.S. history and the number of judges, sometimes even numbers, sometimes odd numbers. And although we've seen it change led by the legislative branch, it has not changed in recent years. That is one of the checks on the judicial. And of course, impeachment is not just for those presidents. We can impeach judges who have held their power tyrannically. So, how can the judicial branch check the powers of other branches? Well, the judicial branch can determine the constitution of executive actions. That's done through reviewing executive orders, which we've seen every president in recent history have numerous executive orders struck down. And in recent years, we see a good amount of debate and attention put towards this check on the executive powers. We also see they limit executive enforcement at times and constrain wartime and emergency powers under certain circumstances. The legislative branch, the judicial, can act as a check on them by determining the constitutionality of legislation, by limiting the implementation of certain legislation or striking down certain legislation altogether and how it can be implemented. So, a lot to learn this week, but a lot of this is easy to remember. We focused a lot on individual landmark rulings, which you've already engaged with on some level in your experience in your life. So it's important that we have uniform understandings of how these how various courts have provided interpretations of our Constitution through U.S. history. And here are those answers. Thank you guys for listening to me. Make sure you go through the modules tab to ensure that you're doing all the required work, discussions, assignments, everything. Remember, you don't do those discussions, you can't even get an A in this class, so make sure you contribute and participate, complete those assignments. Rarely will we have a week where we don't have any assignments or quizzes, and you will always be able to see what is due in the modules tab and the tab of the week. So thank you for listening to me. Thank you for rambling with me. Make sure you read those readings. Make sure you do that work, and I will talk to you guys soon. Thank you.